Almost every firearms attorney on the internet will tell you the same thing about applying for a federal firearms license or a concealed carry permit after the age of 60. Wait until you have the perfect record. Make sure everything is in order. Do not rush the process. And whatever you do, never apply at age 60 or older because the approval rates drop, the scrutiny increases, and you will almost certainly face delays, denials, or complications that younger applicants never encounter. That is the conventional wisdom. That is what gets repeated in gun forums, in YouTube comments, and in the waiting rooms of firearms attorneys across the country. And for an enormous number of Americans over 60 who have every legal right to own and carry a firearm, that conventional wisdom is factually wrong, strategically backwards, and financially costly in ways that most people never calculate. In this video, I am going to walk you through the 7 specific situations where applying for a firearm license at age 60 is not a mistake, but the single most legally protective and financially sound decision a senior gun owner can make. And here's what makes this video different from everything else you have watched on this topic. Most of the content about firearms licensing for seniors is produced by people who benefit from you staying confused, staying delayed, and staying dependent on their ongoing services. I am going to give you the complete picture, including the information, the DOJ's own enforcement posture, the ATF's processing priorities, and the mainstream firearms community's conventional advice all conspire to keep you from understanding clearly. The seniors who delay their firearms licensing applications after 60 in the wrong situation pay thousands of dollars more in legal fees, lose access to rights they could have been exercising for years, and miss the single most important compliance window of their entire ownership history. The seniors who apply at 60 in the right situation use the application process to establish a documented protected legal record that shields them from enforcement actions, estate complications, and family transfer problems. That will absolutely find them if they wait. That is not theoretical. That is what the actual compliance and legal data shows when you run it for a real senior gun owner situation. I am going to give you all 7 reasons. But first I need to tell you about a real situation I encountered recently, because it is the perfect counterexample to the wait-and-see conventional wisdom. And once you understand what happened, you will understand exactly why the standard advice fails so many seniors so badly. I want to tell you about a man I will call Gerald. Gerald is 64 years old. He spent 31 years working as a machinist in a manufacturing facility in Ohio. He retired at 62. He has owned firearms legally his entire adult life, a collection accumulated over 4 decades that includes hunting rifles, shotguns, a couple of handguns he carried for home defense, and several items he inherited from his father and grandfather. He has never had a criminal charge. He has never had a domestic incident. He has a completely clean record. When Gerald came to me, he had been told by 2 different people, one a gun store employee, one a friend who considered himself knowledgeable about firearms law, that because he was retired, because he was over 60, and because he did not have a current business need for a federal firearms license, there was no reason to pursue any formal licensing beyond the basic state permits he already held. The reasoning both of them offered was the same. He was not a dealer. He did not need to transfer large numbers of firearms. He was just a hobbyist and a home defense owner, and the federal licensing process was not designed for people in his situation. Here's what neither of those people mentioned. Gerald had, over the course of 4 decades of collecting, acquired several items that crossed into National Firearms Act regulated territory. He had inherited a suppressor from his father that had never been properly transferred into his name. He had a rifle that a gunsmith had modified years ago in a way that may have changed its legal classification without anyone telling Gerald what that modification meant under federal law. And he had gifted 2 firearms to his adult sons over the years through informal transfers that did not go through a licensed dealer. None of those things were done with any criminal intent. All of them were done without complete information about what federal law required. And all of them represented compliance gaps that the ATF's modernized enforcement infrastructure is now specifically designed to identify and pursue. When we walked through the complete picture of Gerald's collection and his transfer history, the exposure was significant. The path forward required formal legal documentation, properly executed transfers, and a clear compliance record established proactively rather than reactively. The seniors who wait until they receive a federal notice to address these issues deal with them in the most expensive, most stressful, and most legally dangerous position possible. The seniors who address them proactively, who apply for the appropriate licenses, complete the appropriate transfers, and establish the appropriate documentation records before enforcement finds them, deal with them in the most protected, most efficient, and least costly way available. That is the story almost nobody in the mainstream firearms community is telling seniors over 60. So let me give you the 7 reasons it needs to be told clearly right now. The first reason is the one I lead with, because it is the single largest legal protection opportunity that most senior gun owners are missing right now. And it is the reason that gets completely ignored in every conventional discussion of firearms licensing for older Americans. The federal regulatory environment around firearms compliance rewards gun owners who can establish a clear, documented, proactive compliance record during the years before any enforcement issue arises. The years between when you retire, when your collection and transfer history becomes most complex, and when the ATF's enforcement systems are most actively cross-referencing estate records and ownership histories against registered transfer databases. Those years are the most valuable compliance documentation window of your entire ownership history. If you can fund that documentation window by formally establishing your licensing status, completing any outstanding transfer paperwork, and creating a clean legal record of your entire collection during this period, you create an enormous protective buffer against the enforcement actions that are increasingly being directed at senior gun owners with complex ownership histories. Instead of paying 22% more in legal fees when a federal notice arrives and forces you into a reactive compliance posture, you address everything at the 12% cost of proactive documentation when you control the process and the timeline. The math on this strategy for a senior gun owner with a collection accumulated 30 or 40 years almost always saves more in legal fees and penalty exposure than the conventional delay approach costs. Almost always. And almost nobody in the mainstream firearms community talks about it, because to explain it properly, you have to understand the ATF's enforcement posture as well as the firearms licensing rules. That is where we are starting, because everything else builds on it. The second reason applies to a larger population of senior gun owners than most people realize, and it involves a compliance gap that is sitting in millions of households across the country right now, accumulating legal exposure every single day it goes unaddressed. If you have transferred a firearm to a family member informally, at any point for any reason, with any level of good intent, without going through a federally licensed dealer and completing the required background check process, that transfer is an unresolved compliance issue under federal law. And the ATF's current enforcement infrastructure is more capable of identifying those informal transfers than it has ever been in the history of federal firearms regulation. The conventional advice senior gun owners receive about this situation is to do nothing and hope enforcement does not find them. That advice was marginally defensible when the ATF's data systems were fragmented and manual. It is not defensible in 2026 when estate records, deed transfers, social media posts, and dealer records are being cross-referenced automatically against registered ownership histories in ways that surface informal transfers that happened years or even decades ago. Every day you delay addressing an informal transfer is a day you remain in a compliance posture that the ATF systems are actively designed to flag, applying for the appropriate licenses, completing the appropriate transfer documentation, and establishing a clear legal record of your current collection is how you close that exposure window before enforcement finds it for you. The third reason is one that even conventional firearms attorneys will sometimes acknowledge but rarely quantify specifically enough to make the stakes clear. If your family has a history of firearms ownership across multiple generations, if you inherited firearms from a parent or grandparent, if those items included anything that might be NFA regulated, if any of those items changed hands without formal documentation at the time of the original owner's death, you are holding potential estate liability that grows more complex and more expensive to resolve with every passing year. The break-even point between addressing inherited firearms documentation proactively and waiting for estate complications to force the issue is not the dramatic legal crisis moment most people imagine. It is a quiet, gradual accumulation of legal exposure that surfaces when you sell a home, when you update your own estate plan, when a family member tries to transfer ownership of an item after your death, or when any one of a dozen routine life events triggers a records check that reveals an undocumented chain of ownership. If your father owned NFA items, if those items passed to you without formal ATF transfer documentation, if you have been in technical illegal possession of them without knowing it, the time to address that is while you are alive, legally competent, and able to work through the process proactively. Not after your own death when the burden falls entirely on your heirs in a far more complicated and expensive legal environment. The fourth reason is specifically relevant for married senior gun owners, and it involves a compliance dimension that almost nobody discusses clearly in the context of spousal firearms. In households where both spouses have an interest in the firearms collection, where both spouses access shared firearms for home defense, where both spouses have been effectively co-possessing items that are legally registered to only one of them, there is a documentation gap that becomes acutely problematic the moment one spouse dies, becomes incapacitated, or is otherwise removed from the household. If the legally registered owner of an NFA item dies and the surviving spouse continues to possess that item without completing the required ATF transfer process, that surviving spouse is in illegal possession of a regulated firearm under federal law, regardless of how long they have lived in the same household with that item, regardless of their own clean record, and regardless of their complete good faith. The formal licensing and documentation process that establishes each spouse's independent legal standing in relation to the household's firearms collection is not bureaucratic overkill. It is the specific protection that prevents a surviving spouse from becoming a federal compliance problem at the worst possible moment of their life. For married couples where one spouse is over 60 and the collection includes any NFA-regulated items, establishing independent documentation now is the financially and legally sound decision. The fifth reason is one of the most widely overlooked in the senior gun owner community, and it is relevant for any retiree who intends to pass any portion of their firearms collection to the next generation, whether through estate planning, through lifetime gifts, or through informal transfers made with the intention of keeping valued family firearms in the family. The federal legal framework for transferring firearms to family members is not the simple private transaction most people assume it is. And the gap between what most senior gun owners believe about family firearms transfers and what federal law actually requires is wide enough to create serious criminal exposure for both the person giving the firearm and the person receiving it. Establishing the appropriate formal licensing status and documentation infrastructure before you begin any intentional transfer process is what separates a legally protected estate plan from an accidental federal compliance nightmare for a senior gun owner with a collection accumulated over 30 or 40 years who intends to distribute that collection to adult children and grandchildren. The cost of establishing the proper documentation framework now is a fraction of the legal fees those children will pay if they inherit an undocumented collection and try to sort it out after your death. The dependent benefit of doing this correctly while you are alive, why you can explain the provenance of each item, why you can participate in the transfer process, why you can work with an attorney to structure the transfers in the most legally efficient way is worth more than most senior gun owners ever calculate until they see the alternative play out in someone else's estate. The sixth reason catches more senior gun owners off guard than almost any other compliance issue in the current enforcement environment, and it involves items that were completely legal at the time of purchase, but whose legal classification may have shifted under subsequent regulatory changes without anyone notifying the original owner. This is not a hypothetical concern. The ATF has issued multiple rule changes, clarifications, and reclassifications over the past decade that have retroactively changed the legal status of specific items, bump stocks, current pistol brace configurations, specific receiver designs, and in many cases, the owners of those items received no direct notification that the item they legally purchased now required either registration, modification, or surrender. If you have owned firearms for 30 or 40 years and you have not had a comprehensive legal review of your entire collection in the last 2 to 3 years, there is a meaningful probability that something in your collection has been affected by a regulatory change you did not hear about. The formal licensing and documentation review process is the mechanism by which that exposure gets identified and addressed before enforcement identifies it first. The difference between discovering a reclassification issue through a proactive attorney review and discovering it through an ATF enforcement action is the difference between a manageable compliance correction and a potential federal prosecution. For any senior gun owner with a collection of meaningful size and age, the review that comes with establishing a formal compliance record is worth far more than its cost in legal fees. The seventh reason is the one that every senior gun owner needs to take seriously because it is grounded in the documented trajectory of federal firearms regulation and the political reality of where enforcement priorities are heading. The window in which senior gun owners can establish their legal compliance record, address outstanding documentation gaps, complete outstanding transfers, and formally protect their collections is open right now. There is no credible basis for believing that window will be more open, more forgiving, or more practically accessible in 5 years than it is today. The ATF's enforcement infrastructure is more sophisticated today than it was 2 years ago. It will be more sophisticated 2 years from now than it is today. The data sharing agreements between federal agencies and state-level record systems are expanding, not contracting. The automated cross-referencing of estate records, deed-transfers, and ownership histories against registered transfer databases is becoming more comprehensive with every passing year. Every year a senior gun owner waits to address an outstanding compliance issue is a year in which the enforcement system designed to find that issue becomes more capable of finding it. The bird-in-hand argument for establishing your compliance record now, rather than later, is not a philosophical preference. It is a mathematically sound response to a regulatory environment whose trajectory is clearly and consistently in one direction. The seniors who establish their documentation record now do so in the most permissive and most practically accessible environment they will ever face. The seniors who wait do so in an environment that is harder, more expensive, and more legally dangerous with every passing year. Before I close, I want to describe the situation that is the dark mirror of the 7 reasons I just walked through, the trap that catches senior gun owners who follow the conventional wait and see advice without understanding the full picture of what they are actually waiting for. I call it the compliance torpedo, and it is the single most expensive mistake senior gun owners make when they enter their late 60s and early 70s with unresolved documentation gaps still sitting in their collections. Here is how the compliance torpedo works. You waited, you did not address the informal transfers. You did not complete the NFA documentation for the items you inherited. You did not get the legal review of your collection that would have identified the reclassification issue with the item you bought in 2009. Your collection has been sitting as is for years, and nothing bad has happened, so the conventional wisdom felt right. Then one of 3 things occurs. You die, and your heirs discover the compliance problems under the worst possible circumstances. You become incapacitated, and the estate process exposes the documentation gaps when there is no longer anyone who can explain the provenance of the items or the ATF's enforcement systems, cross-reference your estate filing against your registered ownership history, and generate a notice that forces your family into a reactive legal posture at enormous cost. The families who get hit hardest by the compliance torpedo are exactly the families where the senior gun owner followed the conventional advice, delayed their documentation, and never had the comprehensive legal review that would have identified and resolved the issues while the cost of resolving them was still manageable. Filing for the appropriate licenses, completing the appropriate transfers, and establishing the appropriate documentation record at age 60 is the cleanest way to avoid the compliance torpedo entirely. This is why the 7 reasons matter. This is why the conventional wisdom is wrong for so many senior gun owners. And this is why every senior gun owner watching this needs to get an actual comprehensive review of their collection's compliance status, including the transfer history, the NFA documentation, and the current regulatory classification of every item before locking in a decision to simply wait and hope. Let me close with the single most important point in this entire video. The decision of how and when to formalize your firearms compliance record is the single largest legal protection decision most senior gun owners will ever make. It interacts with your estate plan, your family transfer intentions, your NFA exposure, your spouse's independent ownership standing, and your heirs' ability to cleanly inherit your collection in ways that no online forum post and almost no general firearms attorney will fully model for you. The conventional advice to wait and see is right for some situations. It is catastrophically wrong for many others. And the only way to know which category you are in is to get an actual comprehensive review of your specific collection's compliance status, including the transfer history, the regulatory classification questions, and the estate documentation gaps before the ATF's enforcement systems make that determination for you. Applying for a firearms license at age 60 is not a mistake. For the 7 situations I just walked through, it is the single most legally protective and financially sound decision a senior gun owner can make. The seniors who face the most serious legal exposure in their 70s and whose families face the most complicated and expensive estate problems are not the ones who address their compliance proactively. They are the ones who follow generic advice without doing the legal analysis specific to their actual situation. If this video gave you clarity, share it with every senior gun owner you know who has a collection of meaningful size and age and has not had a comprehensive compliance review in the last 2 years. That one conversation could save them and their family from an outcome that costs far more than it ever needed to. Subscribe, because these updates keep coming throughout 2026. Drop your specific situation in the comments. I will see you in the next one.